Assalamualaikum warahmatullahi wabarakatuh. My name is Farzana Islamat. Today I will be sharing with you our research finding entitled Distinguishing Justice Prosecuting Act of Terror by National Liberation Movement as a War Crime. Without further ado, we go straight to the introduction, where National Liberation Movement can be constituted as a diverse socio-political movement or armed struggle that are waged by people to achieve their right to self-determination. So the main aim of this movement was to establish an independent state of what they consider as nation within borders of territory recognized by international community. However, post the attack of 11 September the 11th, some part of the international community held the view that there is a possibility of an act by national liberation movement in the use of force that can be constituted as an act of terror. So this affected the exercise of right to submission by the NLMs, where in some cases there are NLMs that are classified as terrorist organizations such as Hamas in Palestine by the US and EU, and also in cases where acts of violence that are classified by state municipal law as act of terrorism is subjected to prosecution of the state law, which the whole notion is in contrast with the terrorism law, the international terrorism law, where it stated that terrorism law does not apply in armed conflict, especially so where international humanitarian law prevail, and this is supported by various UN documents pertaining to international terrorism law. So to answer whether we can prosecute act of terror by national liberation movement as a war crime, we need to look back the legality of use of force by the movement. So we found that national liberation movement has permission to use under international law to use force to exercise their right to self-determination, and this is supported by 4 facts. The first fact was that the prohibition of use of force provided under Article 2.4 of the UN Charter is not applicable to non-state actors, and this is supported by the fact that the article itself started with the term all members, which generally understand as UN state members, and this is recognized by the court in the case of Nicaragua, where the court find that the prohibition use of force under Article 2.4 is not applicable to non-state actors. And the second fact was that the report of Special Rapporteur on Right to Submission state that use of force by people subjected to colonial rule instigated by colonial powers did not deviate from the prohibition use of force of Article 2.4. And the facts that there is no explicit prohibition in reference to Lotus case, where permissive rule is not required in the absence of prohibition. The absence of prohibitions of use of force by NLMs can be seen as a permissive rule for them to use force, and the 4 facts was that in Chaco's advisory opinion, the court find that there is no specific mechanism to exercise right to self-determination under international law, under customary international law. So it can be understand that use of force is one of the legitimate methods that can be used by national liberation movement to exercise their right to self-determination. So what is the effect of terrorist designations on national liberation movement? So terrorist is an illegal combatant under international humanitarian law, where legal combatant enjoy combatant immunity, where they are permitted to kill military object, and also they are protected by the Geneva Convention under international humanitarian law. However, in cases of non-state actors, it's only applied to international armed conflicts, which can be said non-state actors in non-international armed conflict did not enjoy the protection of the Geneva Convention. So, fight for self-determinations supported by Article 1, Additional Protocol 1, and to be read together with the UN General Assembly Resolution 3103 is an international armed conflict by character. So, in other words, national liberation movement that use force, that use armed struggle as one of as their method to exercise their right to self-determination is protected, is legal combatant. So by designing them as a terrorist organization, make them prone to be not be protected under international humanitarian law, and make them as an illegal combatant, which is in contrast and defeat the purpose of international humanitarian law itself. So how can we combat? The possibility of the national liberation movement who use act of terror? How can we prosecute them when the terrorism law is not protected and they are not terrorists? So how can act of terror by national liberation movement can be prosecuted under international law? So the first instance that need to be understand is that under international terrorism law, the act of terrorism itself cannot be prosecuted by the international criminal law. This is due to the fact that there is no universally accepted definition where terrorists and armed revolutionists and national liberation movement, due to their similarities, make some members refuse to acknowledge the proposed definitions of the fact of the acts. And also some of the UN state members refuse to acknowledge the use of force as a form of recourse for any reason. So due to that, without universal definition, the Rome Statute lacks the provision and has no jurisdiction to try any international terrorism crimes. However, this does not shut down the possibility of act of terror can be prosecuted in international criminal court as a war crime, even though the facts that Hague Convention does not have a clear distinctions of terrorism from other war crimes. But the fact that Additional Protocol 1 and 2 provides that acts to spread terror is prohibited, that it shows that act of terror itself is a war crime, but without a specific, however, in this case, we can try to use the application of Article 8 of the Rome Statute to prosecute act of terrorism, because Article 8 of the Rome Statute, the act that falls under war crime under Article 8 of Rome Statute has a similar distinction, can be constituted, has some similarities to act of terror or act of terrorism. So this allow act of terror by national liberation movement can be prosecuted under international humanitarian law. So it can be prosecuted as a war crime. It can be prosecuted under international criminal law, criminal court. So this does not. This shows that there is no lacuna of law that provide protection for national liberation movement from using act of terror as one of their modus of armed struggle. So in conclusion, international law does not prohibit national liberation movement use of force to realize their right to self-liberation. However, the act of terror by national liberation movement is still illegal, but it does not invalidate the struggle itself. as can be seen in Kosovo Special Court, where war crimes by National Liberation Movement can be prosecuted after the realization of right to self-determination by the LNMs. Because at the end of the day, the right to self-determination, the struggle for it was to realize life with dignity and honor. And by using act of terror, such act will tarnish such honor and dignity itself, and it will defeat the purpose of achieving right to self-determination. Thank you.